Mikey D, can you hear me?
Is it better if I do it this way?
No, if you could do the other way, that'd be best.
Should I put on the collared shirt?
Oh, it's up to you. I like the stars. I think that's the way to go.
Well, it's the start zone.
Start zone. Hey, are you ready to be overheard? Because I got to do like the sound checks.
Yeah, are you sure you want me to put on that shirt?
Oh, I love that. Love the Stark Zone, man. I kind of wish I had the Stark Zone shirt myself.
Well, what about McGinley's zone?
That would be another good shirt.
Make that happen.
All right, now I got this thing to hold the phone. Whoa! As you can see, I just dropped the phone. All right, there we go.
Because my wife said I should wear a collared shirt.
Oh, you wear what you're comfortable with, man. Let me see. Now, Patrick spent, my son Patrick James, I don't know how many hours today setting this up that you're going to go through this. And now I'm doing it wrong. Bear with me. Let me go get him.
Yeah. Don't worry, man.
Okay, I'll be right back.
Okay.
Hey, Patrick. I'm so sorry to interrupt you, buddy. But if you could help me, I'm live on the internet. It's not working. And I know it's not your setup. I know it's me. I don't know what I did wrong. I know you got this set up perfectly, Patrick, but I don't know what I did wrong. See, Mike's there, but he's not there. I need him there. Hello, world. Okay, this is my son, Patrick James. He's the brains of this operation, especially when it comes to the technology.
You should pay him for IT work.
Patrick, how much did you want for this IT work?
I didn't want anything.
All right, then that's what you'll get. Well, kind of lighting the studio up. Is he there? Oh, he's there. Hey, Patrick, you made that look easy, buddy. He didn't stick around for a thank you. I was too busy turning on the lights. All right, let's see now. Actually, this isn't such a bad setup, but I was looking for more of that classroom feel. I was going to get over here. Shoot, look at all the glare I get when I do that. See, since the test run, I added lights. Wow, they're causing me a lot of glare. Well, shut them off. All right. That one didn't make a difference.
Can you see me on the thing?
Yeah. I can see you, and the world can see you. You're not full screen, but you're landscape instead of portrait, so that's a big plus. All right, I lost a little bit of glare. Oh, I lost you all together. Oh, I gotta get Patrick. Hold on, Mike. Hold on. Hey, Patrick, I lost him again. Thank you. Mikey, bear with me, buddy. Patrick James is busy doing whatever 10-year-olds do when their dads are having live YouTube broadcasts. Okay, Pat, why did it go away, and what do I do when that happens so that if you're not here, I know what to do?
So you swipe up,
Swipe up.
and then you hit screen mirroring,
Screen mirror.
and then you hit this thing,
Then I hit that thing.
and then you hit,
And then I get Mikey D.
yeah.
Love it. All right, Patrick, you're the best, buddy. Shucks, there's still a tremendous amount of glare. I think that's a window. Let me try closing Venetian. Mike, one thing I'm hoping that's going to come through for me is that the sun is setting. Then I'll get less glare from the windows. All right, less glare, less glare. Yeah. Still not 100% happy with it, though. Oh, close another window. Okay. All right. Okay. I've now lost 4 lights and 4 windows. How's the glare? No difference that time. Shucks. I don't know where. Mikey, I lost you again. We did a test run, 2 of them today, and we had other problems, but never with the screen mirroring. I'm not sure why that's timing out. We don't want to lose your words of wisdom in this class here, Mike.
I know, it's so critical.
Oh, and it's 5:40.
Maybe Pat could just. Maybe Pat could
Hello,
just hang
class.
out.
If you're there, you might recognize me. Yes, I'm here too. Thanks for joining me. I see I've got 31 of you watching. That's pretty close to 49. Experiencing technical difficulties, please stand by. It's going to be a great class. Patrick, I couldn't figure it out. Can you? Thanks again, buddy. Oh, if you missed the earlier introduction, this is my all-time favorite boy, Patrick James. Say hello, Patty.
Hi.
Hey, love this boy. All right, thanks. Years old, smart as a tack, knows the technology better than I do. Pat, it's still not there. Patrick, please come back. Were you here for a comedy routine? Because I got one. All right, Patty, it's not there. This part worked great with Miss White on the test just 2 hours ago. I'm doing something.
Hang out for a bit.
Oh no, IT guy's off to Park Avenue Pizza, Mikey. You don't want to miss your pizza, do you, Pat? I love the shakes. But I don't know if you noticed the podium. Got that off of Amazon.com. So holds book. So that's nice. Also holds the computer that runs the slides. So that's nice. Apparently shaking an iPhone helps it work better. Oh, Patrick is going to figure this out because he had it flawless before. All right, there we are. Okay. Patrick, any advice on like why it times out?
I have
Or should
no
we
clue.
touching the screen now and then, anything like that?
I have no clue.
No? All right, thanks. Mike, you're with us, right?
Oh, yeah.
All right, and let's see, we've got 39 viewers, so that's quite a few. All right, Bernadette, looks like I'm in good shape. Will you wish us luck?
Good luck. God bless us all.
Yes, God bless us all. All right, welcome everybody, welcome. You know me, Patrick McGinley. You know the class, Florida Constitutional Law. And typically we do this face to face. And 6 months ago, hey, even 6 weeks ago, who would have predicted this? And when I say this, you know what I'm referring to. Who would have predicted that Tom Brady would be the coach of the Tampa Bay Buccaneers? Mike, would you have predicted that?
Never.
Never.
I feel very deflated.
Oh, Mike, we lost you again. All right, but that's okay. Mike, I'm going to get you back in a minute, but just doing my intro real quick for the class. And we'll get Mikey back in a minute. But hey, and I'll try to do a proper intro of you too, Mike. But until then, we'll start the class. We'll start the class by saying this is the same class this class has always been. Oh, except I've got a 10-year-old tech guy. It's the same class this class has always been, and I'm going to deliver the same quality of instruction, minus the technical problems that I've always promised you. I plan on serving you well this semester, and this glitch of not being live on campus, it's not going to slow me down. Is it an obstacle? Sure, but life's full of obstacles, and that will always be true. No one could have predicted these particular obstacles, but life brings obstacles. And the Lord our God in his infinite wisdom has not left his people without others who help those who face obstacles. And you know what profession I'm talking about. I'm talking about our profession. I'm talking about attorneys. I'm talking about lawyers. When citizens have obstacles, when they're trying to get through the legal system, when they want to know what their rights are, who do they turn to? They turn to a lawyer. They turn to an attorney. If you've joined me today, so far 42 of you have, come on 49, we can do it. Come on tech, we can do it. If you've joined me today, you have overcome an obstacle, and you'll continue to do that throughout your lives. Better yet, you will be part of the profession that helps others overcome their obstacles. That's why I think our profession is so Christ-like, because we literally shoulder others' burdens. We pick up their crosses. We help them carry their crosses. So just as I've started every class this semester, I start this class with a prayer, just like those other prayers. What is this prayer for? Who is it for? This prayer is for you. It's for your success, despite the obstacles. It's for your success in successfully joining the profession that helps others overcome their obstacles. Mikey, you ready for a good prayer?
Yes.
Amen, brother. And here we go. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. O my Jesus, forgive us our sins. Save us from the fires of hell. Lead all souls to heaven, especially those in most need of thy mercy. Jesus, I trust in you. Jesus, I trust in you. Jesus, I trust in you. Amen. In the name of the Father, Son, Holy Spirit. Amen. So who is this guy over here on my Apple iPhone, but apparently not on my big screen? Hey, you're Mike. How you doing? Can everybody see Mike? This is Michael D. Starks, Esquire. Mike, say hello, buddy.
Hello. Can they hear me? At least?
Oh, yeah, they can hear you. It's the C in your part that I'm hoping to pull off. So apparently the screen mirroring, I don't know why. We tested this earlier, worked just fine, but for whatever reason, hey, if I got to sit down at a desk and put you next to me on a iPod or an iPad or iPhone, that's what I'll do. We'll try one more time to get the screen mirroring up and running. Patrick James is off to Park Avenue Pizza, so.
Okay.
Hey, your audio's coming through the screen. I bet you'll have some video in just a minute.
Okay.
Yeah.
Do you just want to start and see how it goes, or?
Give me 20 seconds. This little dial is spinning. Sometimes if you hit it again, maybe. I don't know. Screen mirroring. Screen mirroring. You know, no matter how many practice runs you do, you got to deal with the fact that sometimes there'll be tech problems, right? But obstacles, that's what we overcome. Because we're lawyers. And we're right.
That's right.
All right, here's what I'm going to do. I'm going to put you back on this little screen. All right. Get you going that way. All right, here you are. Let's see if I can get you a little closer here. All right, there's Mikey Starks. Mikey, how you doing, buddy?
I'm doing good.
All right.
I just see the top of the screen, but if they can see me, that's fine.
That's great. Yeah. So, Michael, today we're talking about Article 5 of Florida's Constitution. Article 5 has to do with judiciary.
That's right.
I know that you've looked at. Oh, I didn't do a proper introduction of you first. I should talk about you, right? I first met Mikey back in 1993. So we were both 2 years old. We were in law school at Florida State.
I think we met the first day of law school, actually.
Yeah, I'm pretty sure we did. So you used to eat a lot of pizza back then. You remember that?
I did. That's why I look this way.
Oh, come on, man.
But I do appreciate you asking me to do a guest lecture on this, and I think I'm highly qualified to teach this because those who can't do teach. But
Great analogy.
But I mean, if you want to just get started, I can do my best.
Let's do this. Now, Article 5 talks about our state court system. So, Mike, if I could ask you, why bother having a state court system when we've already got a federal one?
Well, that's a good question, Pat. There's a really, really excellent book on constitutional law.
Oh, I love that book.
Yeah, it's fantastic. It's
Buy one for yourself and all your loved ones.
There are parts of it that are Shakespearean almost, the quality of writing. But there's a really good law review chapter article that's quoted in here. It talks about that the primary purpose, of course, for the state court judiciary is back when our country was founded, most of the activity in the state was all done in the states. It wasn't done by the federal government. In fact, I don't know if you've ever read Democracy in America. I've been listening to it on audiobook right now. It's written by the French aristocrat Alexis de Tocqueville, who toured. It came out in 1776. I'm sorry, it was in 1780 something. But it came out, and basically he was talking about his concern that Americans didn't have a lot of protection because of having elected judges, and the lack of disconnect between the people and the tyranny of the majority and the state elected judges. And he didn't feel like it was a problem at the time because there was a high moral character among Americans, but he foresaw that if they...
Oh no! Did you see me?
Yeah, I see you.
Sorry. All right, I'll try to be more serious. So I know it's your first time in my class.
I thought you were trying to tell me something, but
No. I know it's your first time in my class. We get a lot of work done, but we play a lot while we do it.
No, that's fine. But anyway, he just got me there. But he was concerned because the judges were all elected, and unlike the federal government, where they were appointed and then ratified, and he saw a real concern about that. But back in the day, I know it's hard to think about now, but people used to think of themselves as citizens of states because that's who did everything. The federal government did very little. They did maritime, they did interstate commerce, tariffs, that kind of thing. But it was very, military, but it was very small compared to what the states would do. So we need a state court system for that reason. And because the federal jurisdiction of the federal courts is much more circumscribed, it's very small compared to the states, although it's gotten bigger over time. So that's why we need a state court judiciary, Patrick.
All right. Well, that makes sense. So now help me out with the vocabulary, will you? Because sometimes I'll meet some lawyers and they'll be talking about the district court. Sometimes I'll be meeting some lawyers and they'll be talking about the Court of Appeal or what's the language different? How does this work when it comes to state versus federal?
Well, it's exactly reverse. In the federal system, the lower courts or the trial courts are called district courts, and the appellate courts are called circuit courts. And then there's the Supreme Court, of course. In the Florida system, it's exactly reversed. The lower courts are called circuit courts, and the appellate courts are called district courts. So it's very confusing. But of course, in Florida, we have basically two levels of trial courts. We have the county courts, and we have the circuit courts. And both of them are divided into circuits. And I think I gave you the little chart, Patrick.
You sure did. And I'm pulling that up on the big screen right now.
Okay, so they can see it.
Well, in a minute they will.
Yeah. Well,
Am I smarter than a 10-year-old? We'll find out. We'll see if I can get the big screen up and running with the video.
Because this chart is going to change your life.
You'd never know I rehearsed this live on YouTube prior to this. You'd never know. Okay. Look at that. At least I hope you got it. Well, I think so.
Is that the circuit and is this the one with not the DCAs, but the circuits?
Yeah. So we're talking about Article 5 of Florida's Constitution, Florida State's Court and Judiciary, and we're live with Michael D. Starks, Esquire, my buddy, my friend. All right, and here, my friend, is our first map. Here I start with the state of Florida. Can you see it? Then I got a first district, second district, third district, fourth district, fifth district. Now I'm talking about my state court system. Isn't that right?
Right. And it looks like the one I'm looking at is is this the one you got right here? The circuits? I'm sorry, districts?
Yes.
Okay.
Here's my districts.
Yeah, districts. So that's
Let me give this brief introduction. Here we see the geographic boundaries of the appellate courts in our federal system. Now, what we know there, of course, is that when it comes to the appellate courts that have a geographic boundary, we've got 11 U.S. Circuit Courts of Appeal. Compare that to Florida State Court System. Here we have 5 separate districts for our district courts of appeal, 5 courts, which are primarily appellate courts.
Can you hear me, Patrick?
I can. Now, when it comes to districts in the federal system, our district courts are primarily trial courts. And we've got 3 U.S. district courts: the United States District Court for the Northern District, which you see in red, the United States District Court for the Middle District, which you see in beige, and the United States District Court for the Southern District, which you see in blue. That's our federal system. Those district courts are primarily trial courts. Whereas when we talk about the courts that are primarily trial courts in our state system, we don't call them district courts. We call them circuit courts. So here's the map that Mike was focusing upon. That map shows us that there are 20. Is that right, Mike?
Yeah, 20.
Yeah.
And we are in, well, when I say we, I mean in Orlando, we're in the 9th, which is Orange and Osceola counties.
Yeah.
And the ones that I primarily practice in are Orange and Osceola, and or Seminole County, which is the 18th Circuit, which is Brevard and Seminole. But each circuit is at least, well, except for Dade and Monroe and Broward, like the South Florida ones, Palm Beach. Typically, your circuits are going to be at least 2 counties. Some of them are as many. I think one is as many as 6 counties up in North Florida.
Okay.
But that's how the circuits are divided. And so a judge that's elected, and I've seen this where a judge might normally sit in Orlando, but then they go to Osceola sometimes, or they might normally sit in Osceola, but sometimes they go to Orange. It just depends. But the circuits, of course, there's also county courts, and typically the way you decide whether you're going to be in a county court or the circuit court is really typically based on how much money you're fighting over. And I was going to try to find, Patrick, you have a little discussion of that in the book.
Yeah, sure do.
Yeah.
So what we've got is an amendment to Florida's Constitution that is effective just this year.
Right. It's matter of fact, I think up until December 31st, 2019, it was circuit courts had jurisdiction for anything over $15,000.
Right.
Starting January 1st of this year,
Of 2020.
it went up. What was it? 20? Let me see here.
You're right. I was just pointing out that this year is 2020 because, that's something we don't all know.
I think, this year went up to 30,000. January 1st, 2020.
Yeah.
And then January 1st, 2023 is going to go to 50,000. So county courts are getting a lot more power. And the reason for that, the legislature, their feeling was that, inflation, but also there was a real desire to push, instead of hiring a bunch of new circuit judges, to push some of the work down to the county judges.
Right.
Because they were just, sitting around twiddling their thumbs for comparatively.
But not now, because now we've got county courts. And of course, Florida's Constitution says that each county gets a county court. So you might be the most populous county, you might be the least populous county. You have a county court, and you have at least one county court judge. Based on population, you might get more than one judge, but you've got at least one. And the county courts are going to have original jurisdiction over certain things. For example, if there's a violation of a municipal or a county ordinance, then your county court is going to have original jurisdiction if there's a violation of a municipal or county ordinance. Also, a misdemeanor case that's not cognizable by the circuit court, the county court's going to have original jurisdiction over that. Also, the county court's going to have jurisdiction after December 31st, 2019. If the case is over 15,000. If it's filed on or after January 1st, 2020, 30,000. If it's filed on or after January 1st of 2023, then we're going to go up to 50,000. So when it comes to a civil matter, let's not think of county courts as small claims. Mike, wouldn't you agree? Because currently we're at $30,000 and we're going up to 50.
Yeah, well, the small claims jurisdiction, I think right now is 8,500. It was 5,000 last year.
Yeah.
And right now I think it's 8,500, which is small claims. And those are the ones where typically you're not represented by a lawyer, and people do those pro se for the most part. That's like Judge Wapner, Judge Judy, that kind of stuff.
You're dating yourself with those references, Mike. Judge Mathis is
Yeah.
better reference.
But it's interesting that you bring that up, Pat, about the amount of controversy, which is right now it's $30,000.
Right.
And because the way that's determined
Mhm.
is by the plaintiff. So the person that's suing, they put in their complaint, this is a cause of action for, $15,000 or $30,000 exclusive of interest, costs, and attorney's fees, meaning, it's just the amount of money that they're seeking in damages. And that's based on, the only requirement for that is that it be done in good faith. And so the lawyer basically has to say, what's my claim worth? And it has to do it in good faith. Because if you don't have that allegation in your complaint, then your complaint can be dismissed for lack of jurisdiction because the court doesn't know if it has jurisdiction over it or not, if the other side raises it. Although the court can raise it on its own, or sua sponte.
So if I'm the plaintiff, I'm drafting the complaint, burden's on me to make the allegation, and I have to make it in good faith.
Right. Now, if you say $75,000 and above, then you're probably going to get sucked into federal court. So that's one of the things people decide about how much money. You hear about what somebody sued for $20 million. That's just based on what the plaintiff put in their complaint.
Okay.
That's the only basis for that.
Now here's a question for you, Mike. I file my complaint. I have jurisdiction in the circuit court. They conduct my trial, but I lose. I didn't want to lose, so I'm going to appeal. Where do I file my appeal? After the county court held the trial, and the county court entered a final judgment.
So if you filed it January 1st, 2020, and you sued for less than $30,000, then you're going to be in the county court. And so if you just say you lose.
Yeah.
So
Which, of course, I never would, but
No, you don't lose.
What's a hypothetical?
That's what people say. But the appeal's going to be to the circuit court. And it works just like
hold on there, Mikey Starks. We just finished talking about Florida state court system, and I talked about 5 district courts of appeal that were, in their name, courts of appeal, and that they divided up the state into 5 appellate districts. You're telling me after a final judgment by the county court after a trial, that final judgment doesn't get appealed to the district court of appeal?
Right. Well, it typically goes to, and I do think it matters how much is at stake, because I do think it switches in 2023. But right now, I believe the appeal, regardless of the amount of controversy, would go to the county, would go to the circuit court.
And
So
you're absolutely right. And that's the part I wanted to emphasize. Here's our map. We've got 5 appellate courts. But when it comes to a trial that is heard by the county court, that appeal typically will be heard by the circuit court. Now, the circuit court, I said, was primarily a trial court, but all of our Florida state court system circuit courts have a separate division. That is their appellate division that will hear appeals for which they have jurisdiction from final orders of the county courts. Isn't that right, Mike?
Yeah.
So let's not be fooled by the
judges are
fact that they don't
assigned
have appeal in their name. They still have some appellate jurisdiction, and indeed they have a permanent standing appellate division.
Yeah, and you get the 3 judge panels. The difficulty, and this is one of the things that some lawyers do when they are filing these, say, debt collection cases. What they do is they don't want to make law in the DCAs, the District Courts of Appeal. They don't want to get it to the Supreme Court, Florida Supreme Court. They want to stay in the county court, because the appeal is going to be only one step above the circuit court, where there's going to be these 3 judges. But these 3 judges, they hang out with the county court judges. They eat lunch together. They go to the same functions. They see each other walking down the hall. So the idea is, a lot of lawyers that do that, they think, well, it's going to be less likely for a circuit judge, 3-judge panel to reverse a county court judge who they know and hang out with and probably go to soccer games with.
So that's the word on the street. That's the logic. Is that how it works out?
I don't know. I mean, I've only done a few of those circuit court appeals. You don't have a ton of those.
Yeah.
And Personally, I've never seen it have an effect, but
Okay.
I think that's the logic, and I've been told
Okay.
by plaintiffs' lawyers that is their logic.
Okay.
So, but anyway, but yes, you do have, like you said, you typically will. Now there is, I will say this: if you're in county court and you lose, which again you wouldn't do that, but let's say you
Not
lost,
personally.
you appeal to the circuit court 3-judge panel. If you lose there, you can appeal to the district court of appeal, but it's second tier review, and basically it has to be a violation of fundamental rights, and it's very hard to win at the DCA or the district court of appeal level if you haven't won at the circuit level.
Yeah.
And I don't know if you've ever done those. I've done,
Oh,
I
I
think,
have.
2. It's very, very rare to do
Yeah.
that. So for me, anyway.
Yeah. And that's because that second appeal is not a mulligan. It's not a do-over. It's a higher standard.
Very high, yes.
Yeah.
And so,
Let's talk about
go
money,
ahead,
shall we?
Pat.
Can we talk about money?
Yes.
Yeah. Got my mind on my money and my money on my mind. Let's talk about funding. Here we've got Article 5 of Florida's Constitution. We're talking about Section 14 of Article 5, and that talks about funding. And you can see in Part A that all judges and justices shall be compensated. That's a good thing, right? We don't need volunteers, right, Mike?
Right.
So they'll be compensated, and funding for the state court system, as well as the state attorney's office, the public defender's office, that comes from state revenues appropriated by general law. So, Mike, if we're in the courtroom, we shouldn't bring any money to hand to the judge, right?
No, they get paid by the government, because that would be
Yes.
that would be a problem. Matter of fact, you probably end up in jail.
That'd be a crime. That'd be a crime, yes. All funding for the offices of the clerks of the circuit and county courts shall be provided by adequate and appropriate filing fees. So, Mike, I didn't understand this when I walked out of law school. The clerk of the court is an elected position under Florida's Constitution. Isn't that right?
That's right.
Yeah, so this is an elected constitutional officer who is separate and apart from the judge. This is not like the judge's judicial assistant or secretary. The clerk of the court is an elected position with a staff and with their own funding, as you can see from the filing fees. Article 5, Section 14, subsection C talks about no county or municipality except as provided in subsection shall be required to provide any funding for the state court system. So that raises an interesting question, and I've got it in my notes and questions to consider there, Mike. And I wanted to ask you.
What page are you on there, Patrick?
Oh, page. Let's see. I got a slide. Let's see if I also got a page.
Oh, that's okay. It's okay. I'll find it. Go ahead.
No. I'm gonna find it. Let's see. Page.
Every page is so interesting that I have trouble not just reading the whole thing when I'm looking at it.
There you go. All right. I am somewhere. Here I am. I'm on page 204. I'm on notes and questions to consider. And as my slide says, I'm on note 2. So note 2, notes and questions to consider. Note how Florida's court system is funded. Does this seem adequate?
Well, I can tell you the judges say it's not.
They do say that year after year after year. And that leads to my next question. What can Florida's court system do if funding proves inadequate in any given year? I've come up with some options for them, Mike. Tell me what you think of these options.
I'm ready.
First, they can hope. Next, they could pray. They could dream. They could wish. How about they could lobby? Mike, can they lobby?
I don't know if the judges can do that or not. I know that the bar sections do.
The Florida bar certainly can and does do some lobbying on behalf of the funding for the state court system. Judges
Right.
can
Sections.
speak and therefore lobby on behalf of the justice system, but it must be an indirect call. It must be a call for funding statewide. It can't be, hi, I'm Judge so-and-so from this circuit and I need more money for this room.
Right.
That kind of thing. Instead, it could be, hi, I'm the chief judge of the Florida Supreme Court. I think all courts in Florida deserve more funding. That'd be an appropriate way to do that.
Mm-hmm.
Yeah. And typically you see it in answers given either in the Senate or the House, Florida Senate, Florida House, when a committee is asking questions of the particular judge or justice. So that's how that lobbying typically takes
I
place.
know every time I call the clerk's office to ask a question, I listen to the voicemails.
Yeah.
Not the voicemail, but the recordings. You just sit there for like an hour, and they're explaining the reason you're waiting for an hour is because they're underfunded. That's what.
Yeah.
And so I guess that's their way of saying, hey, if you don't want to wait so long, call your congressman.
Talk you into lobbying on their behalf that way.
Right.
Let me turn to my next slide over my shoulder. Here I'm talking about Article 5, Section 4. I'm talking about our district courts of appeal. The first thing I want to point out is Section 4, subsection A says the three.
About the circuit courts, you're talking about DCAs now, right?
Well, it's
This
true.
court
When the
appeal?
circuit court sits in its appellate capacity, it will sit in a 3-judge panel. Likewise, the Constitution in Article 5, Section 4, subsection A requires the district courts of appeal to sit in a 3-judge panel. What are we talking about there?
Well, you don't want one judge, so if you have two, then obviously that's not good because you're going to have a split, and then they have to duel, which is not good. So they have 3, and then you have to have a concurrence of 2 to decide a case.
Okay, so I don't need all 3.
No, you only have to persuade 2
Yeah.
to get a panel victory, and but yeah, so there's 5 district courts of appeal. Of course, we're here in Orlando. We're located in the 5th DCA. In my opinion, it's one of the best DCAs. And of course, I do bank litigation, and if you're a bank,
Then you can afford Michael Starks.
yeah, if you're a bank lawyer, you want to be in the 3rd DCA. That's the best place for you to be.
Why so?
Followed by probably the 4th or the 5th. You don't want to be in the 2nd or the 1st.
Why not?
Typically. When you look at the case law that comes out
Okay.
weekly, and I do collect it weekly, and I distribute it to.
I know. I see your
probably
Westlaw
150
trail.
lawyers.
Yeah.
The decisions that come out of the 3rd, we like those the best, and it varies by practice area. Of course, you do work comp, right? So Pat, so you're mostly in the
On
1st.
occasion. Yeah. Statewide, the 1st District Court of Appeal hears all appeals in workers' compensation cases.
Yeah. So, but isn't that the only specialty that the DCAs have? I'm not aware of any others.
Yeah. I guess if you look for another specialty, Florida Supreme Court has exclusive jurisdiction over death penalty appeals.
Right.
Statewide.
Right. And but the DCAs, it does. I think you have here, and you have a little chart here, Patrick, right above the note you were just reading. So the 1st DCA is going to be the 1st, 2nd, 3rd, 8th, and 14th circuits, which is a ton of counties.
Yeah.
And then the 2nd DCA is that. So 1st DCA is your North Florida cases. 2nd DCA is your Tampa area. 3rd DCA is your Miami area. 5th DCA is going to be over here in Daytona and Lakeland and Orlando. And then your 4th DCA is going to be your Palm Beach and your Broward DCA. So it depends on where the case is filed, which DCA you're going to get, and then as far as what judges of that DCA you're going to get, because there's usually a bunch of judges in the DCA, the District Court of Appeal. I think some of them have 20. Then they're just assigned randomly right before oral argument. So you don't know what judges you're going to get until you go to oral argument. But what you do is, what I do, and I don't know about you, Pat, when I get an appeal, the first thing I do when I get that panel assignment, I find out who those 3 judges are. I go research those guys. I found out what they did for a living before they became judges. I find out what their political persuasion is, if at all possible. What other hobbies are. A lot of these things are online. You can find, and you find out, what not to say, what to say. If they're really into baseball, you maybe throw in a baseball reference in your oral argument.
Okay.
So that's what I do when I prep for an oral argument. But you don't know who your judge is going to be till right before you actually argue.
Yeah. So if they're into baseball, so are you.
Exactly.
Got it.
Well, they say, what is it? The good lawyer knows the facts, a great lawyer knows the law, and a fantastic lawyer knows the judge.
Well, there you go. There's a cliche. Should I throw that one on the final exam?
Sure, absolutely.
All right. Let me draw our attention to the slide over my shoulder. Here we're talking about the Supreme Court of the state of Florida. And I've often jokingly said that perhaps you should put Supreme in quotes. I'll elaborate on that in a moment. The reason I jokingly say you might put Supreme in quotes is not out of disrespect. No. It's out of the fact that, unlike many state high courts, our state high court does not have as an expansive jurisdiction as many state high courts do. Compared to most state high courts, our Supreme Court has less jurisdiction than many of those state high courts. But to get through their jurisdiction can be a bit tedious. I'll try to keep it entertaining. For example, I've got Mikey here held up by a unicorn. Unicorns are entertaining, right, Mike?
They are very good at it.
Unicorns are entertaining. But
But you know, this book, like I said, this fantastic book.
thank you. Plug the book again.
On page 199 to 200, it goes through the various categories of Florida Supreme Court jurisdiction.
Yeah, talk to me about those,
I
man.
noticed, as I was reading this, captivated, that all the three say may, whereas three of them say shall. So,
Yeah.
like for instance, number 1 says shall hear appeals from final judgments of trial courts imposing the death penalty. And you mentioned that earlier, Pat.
Yeah.
That was one of the things they have to do. And a matter of fact, what I have heard from people that clerk this Florida Supreme Court is this is like the vast majority of what they get is death penalty cases.
Wow. Wow.
So,
Well, you know, they also do my bar grievance cases where I'm defending my fellow lawyers. They
that's
have
true. That's
original
another area I
jurisdiction
guess we
there.
forgot about this bar grievances.
Yeah. Well, if you ever get a grievance, Mike, you call me. But just to start things off, Article 5, Section 3 establishes our Supreme Court of the state of Florida. The Supreme Court shall consist of 7 justices, according to Florida's Constitution. 5 justices constitute quorum. The concurrence of 4 justices is necessary for a decision. So you got to have at least 5 to make the quorum, but you do have 7. We're not sitting in 3-judge panels because you need 4 to reach a decision. When recusals would prohibit the court from convening because of the requirements of the section, judges may be assigned to temporary duty, and they can serve as judges. I remember, Mike, the first time the Florida Supreme Court cited one of my books, it was by a judge that had been assigned to temporary duty. He cited to my book.
Some of the best judges, you see that, are these temporary judges.
I was hoping he'd be permanent after that.
Yeah, there's a judge that sits on the 4th DCA. Sometimes it's a Miami judge, it's just a circuit judge, Michael Hansman. And some of his opinions are just some of the best ones I've seen out of the 4th DCA, even though he's just a circuit judge.
Well, there you go.
And so,
high praise.
Yeah, so but it's I didn't realize that you had to have 5 to hear the case and then 4 to decide it. That's interesting.
Look at that, man! You're not only teaching today, you're learning too.
Yeah, man. But on your listing of areas of jurisdiction,
Yeah.
the first one is the death penalty. That's the shall. Also,
Yeah.
The second one is the shall. The Florida Supreme Court shall hear appeals from final judgments entered in proceedings for the validation of bonds. That's very exciting stuff there. And then the last one is also a shall, and that's when the Attorney General asks them to decide something. But all the other ones are may, which means they can or can't. And in fact, my experience is most of these decisions you read from Florida Supreme Court are one of these may categories, like number 3, which is may review any decision of a district court of appeal that expressly declares valid a state statute, or that expressly construes a provision of the federal or state constitution, or that expressly affects the class of constitutional or state officers, or the big one is, or that expressly and directly conflicts with the decision of another district court of appeal, or of the Supreme Court on the same question of law. Right. Which you mentioned this, Patrick, which is really, for the most part, the DCA, the District Court of Appeal, that's where you're going to stop. That's the final authority that you're going to get to. Most people do not get the Florida Supreme Court. I think in my 23 years, I've only been there once.
Okay.
So the District Courts of Appeal are the final stops.
I like that. So now with the Florida Supreme Court being the final stop, I've then got 5 district courts of appeal. 1st DCA, 2nd DCA, 3rd DCA, 4th DCA, 5th DCA. So talk to me about this, Mike. Say our Florida legislature enacts a new statute. Say there's something in there worth litigating over. It's vague, they don't know how to apply it, what have you. So it makes its way up to one of the district courts of appeal. I'll pick one at random, 2nd DCA. 2nd DCA interprets this statute for us, tells us what it means in light of the facts of that particular case. Now, Mike, where is that binding precedent? And remember our fact pattern. We've got a brand new statute. It's now been before just one of our 5 district courts of appeal. It's been before the 2nd DCA. Where is that precedent? Is that precedent only before the 2nd DCA? Is it precedent statewide? What do we have, Mike?
Yeah, and this is a question that a lot of judges need to be educated on, because a lot, especially the newer judges, and because some people think, well, you know, I'm in Orlando. You know, I'm a circuit judge in the Ninth Circuit, sitting in Orlando,
which is in the 5th DCA, not the second
in the
DCA.
5th DCA, right? And there's this case that this lawyer's arguing out of the second DCA, interpreting the state statute. There's no law in my DCA. I don't have to follow the second DCA. That's what some people would say. But of course, that's wrong.
That's wrong.
That's very wrong. And you know, it's a good way to get reversed, because the Florida Supreme
It's
Court
reversibly wrong.
Well, there's a Florida Supreme Court case that there's a few cases that every lawyer in Florida should know. One is Pardo versus State. It's 596 Southern 2nd, 665. It's a 1992 Florida Supreme Court case. And basically, there's another one that it cites called State versus Hayes. But the idea is, if you're a judge and there's no case law in your district, then you have to follow. Well, there's a couple of things. One is, if there's no case law anywhere but one DCA,
Right.
then every judge in the state has to follow that one DCA opinion.
Okay. So
Every
let me
single judge
repeat
in the
that.
state.
Let me repeat that. If one DCA has ruled, the other 4
Right.
are silent, then the ruling from that one DCA is precedent not only within the territorial jurisdiction of that DCA, but it is precedent throughout the state of Florida. Did I phrase that well?
Right, because the district courts are courts of last resort in Florida.
Right. So let
Yeah.
me take that back to our hypothetical now. Our hypothetical was a new statute, never been before DCA, never had any precedent before, never had any interpretations before. The only DCA that's ruled on is the second DCA. That opinion is precedent not only within the territorial jurisdiction of the second DCA, but statewide throughout the state of Florida, correct?
Correct. Now,
Thank you. And that's important for
but
all of us to
let's
understand.
let's
And
say
that's
the third
why
DCA
Mike calls the DCAs courts of last resort. And that's why you might put quotes around the Supreme in the name Supreme Court of Florida, because all 5 DCAs are courts of last resort. To the extent any one of them rules and the others have been silent, that ruling is precedent, binding precedent statewide. In
Right.
a way, Mike, it's kind of like we've got 5 Supreme Courts. If we want to put Supreme in quotes again. So that brings me to the next part of my hypothetical. You're not getting off that easy. You got one right. No, I'm going to try to get you get one wrong, Mike. You start.
Okay.
You bear with me, buddy. All right. So now let's continue the hypothetical. Let's make it a little bit harder on Mikey. Ladies and
Okay.
gentlemen, was that just a unicorn that he happened to get that one right once? Or was that how it's going to go? Is Mikey going to get them all right? I see you're going for the water. All right. You're ready, Mike, right? To
I don't
continue.
drink water unless it's got coffee beans in it.
Okay, let's continue our hypothetical. All right. Now, some years have gone by. Finally, another case, this time comes out of Orlando, so it makes it before the 5th District Court of Appeal. All right.
Okay.
Now, in this first stage of my hypothetical, don't get too far ahead of me now, because I know you're going to
Got
see
it.
where I'm going. In this first stage of the hypothetical, the court hasn't ruled yet. All right. I'm on appeal. I'm in front of the 5th DCA. I've got statewide precedent out of the second DCA. Now, as a lawyer, can I argue to the 5th DCA that they should rule differently?
Then the second. Yes, you can.
Ladies and
Yeah,
gentlemen,
because-
do you
because-
agree with Michael? Hold on now. Maybe you got it
Sure.
wrong here. Do you agree with Michael? As an ethical lawyer? Yes, Michael is correct. Nice work, Mikey. Yeah. And you can argue as that case comes before the 5th DCA. You can argue to the 5th DCA that they should disagree with the second DCA. That's ethical. That's proper. That's probably good strategy. Don't you agree, Mike?
It is, and you know, the judges should do that too. Like, and you do see that sometimes, where the judge will say, you know what, I disagree with the second DCA, and I'm sitting here in the 5th, but I've got to follow the second DCA, and you can take it to the 5th, and you can tell them the second's wrong.
Yeah, because the trial judge can't say that the second's wrong, but he, after he rules against you, can tell you to go tell him that.
Exactly.
Yeah.
Well, and here's the interesting thing. What if so now let's say the 5th DCA agrees or disagrees with the second.
I told you not to get ahead of me. Yes, that is step 3. I knew you'd see where I'm going. Man, it's
All
brilliant. Step 3 now. continuing the hypothetical. Here in the 5th DCA, you argued that the 5th DCA should disagree with the 2nd DCA. Congratulations. 5th DCA took your advice, believed in your argument, and indeed now there is precedent on the books from the 5th DCA. It says the opposite of the precedent of the 2nd DCA. Now, Mike, can I appeal to the Supreme Court of Florida?
You can.
I like that. We call that conflict jurisdiction.
Under number 3 on page 200.
Thank you. Yes, that's what they're talking about there when they talk about conflict jurisdiction. So you see what's happening. We do have a court that can resolve conflicts. Now, Mike, you've gotten all 3 parts of the hypothetical right, so let me push you further, buddy. Here comes part 4, all right? So the Supreme Court decides not to take jurisdiction. You remember what you said to us just a few minutes ago, Mike, when you're pointing out those mays, may take jurisdiction. Supreme Court of Florida does not have to take jurisdiction. It's not mandatory jurisdiction, this conflict jurisdiction.
Right.
It's optional, it's discretionary. So let's say for whatever reason, Supreme Court of Florida does not take jurisdiction. So now I'm living in a world where the 2nd DCA said up and the 5th DCA said down. The 2nd DCA said the sky is blue and the 5th DCA said the sky is brown. I've got a conflict and I've got a case. Now, Mike, my case is being heard not in the 2nd DCA, not in the 5th DCA. My case is being heard in the 3rd DCA. Which one is precedent?
Well, when you say the 3rd DCA, you mean, let's say, in a circuit court like Miami-Dade?
Yep.
Okay, so you're in a lower court.
Yep.
There's a Tampa 2nd DCA case saying up and a 5th DCA or Orlando case saying down.
That's right. They conflict.
We're in
That's
Miami,
right.
and so what's the judge going to do? Because there's basically 2 opinions.
Mm-hmm.
And here's the result would be the same if there were the other 4 DCAs all said different things.
Yeah.
But so we're in Miami, and the judge in that case can pick.
There you go.
He can pick which one he wants to follow.
He's not
up to any of the other decisions.
Now, the 2nd came out first, earlier, and the 5th came out later. Doesn't that make a difference?
Not at all.
That's right. Everyone, I hope, is catching that. So now, let me make this a little bit harder for you, Mike. Continuing the hypothetical. Conflict persists. 2nd DCA has issued its opinion. The 5th DCA has issued its conflicting opinion. Now, I'm in the 5th DCA. Which one applies?
The 5th DCA or the 2nd DCA?
Yeah.
Well,
So if I'm in the 5th, I'll follow
you follow the 5th DCA.
yeah. What if I'm in the
You're talking
2nd?
about lower courts.
If I'm in the
Yeah.
2nd DCA, I'll follow the
2nd DCA.
okay. So if I'm in the 5th, I'm going to follow the 5th. If I'm in the 2nd, I'm going to follow the 2nd. Mike, are you telling me that in just one state of Florida, with just one statute, there may be 2 persistent and conflicting opinions? In other words, there might be 2 different ways to read the same law?
If the Florida Supreme Court
Yes.
decides not to do anything about it, then there's
Yeah.
there's so many issues. For instance, there's an issue that I litigate a lot, and it's about attorney's fees after a foreclosure. And the 2nd DCA and the 4th DCA disagree completely. And in fact, the 4th DCA has referred to the 2nd and the 5th DCA as following a rabbit hole, which is not a very flattering way to refer to another court's opinions. So, but that conflict, it still exists, and so the Florida Supreme Court doesn't solve every.
Sorry for that interruption, Mike. Someone pointed out on the feed there that Baby Unicorn needed a drink, so I wanted to go ahead and Keep track. Well, go ahead, Mike.
So,
I broke your train of thought. I'm so sorry.
but one thing.
But on the live chat, somebody's saying Baby Unicorn needs a drink. How am I supposed to resist that, Mike?
What was that?
Somebody's telling me Baby Unicorn needs a drink. How am I supposed to resist that? Sorry to break your chain of thought.
No, that's fine. That's fine. It's easy to do.
You're doing great, man. You're doing great. So we've got a state court system that is unlike the federal system. In a lot of ways, it's like it. You know, we notice from time to time that in the federal system, the federal appellate courts, which we call circuit courts, they disagree with one another, and those disagreements will persist unless the United States Supreme Court issues an opinion resolving that conflict. The same remains true here in our state court system. So in our hypothetical, the second issued an opinion, the fifth issued a conflicting opinion. In our hypothetical, Supreme Court of Florida did not exercise jurisdiction, and the conflict persisted. So just like there can be conflict on the federal stage, likewise, there can be a conflict here on the state stage.
And Patrick, when you're advising clients, because I run into this a lot, when you're advising banks, for instance, and they do work, of course, across the state.
And they pay the bills, right?
They do pay the bill. And one of the things that you have to keep track of is what the DCAs are saying about different issues, because it does matter where the litigation is.
Yeah.
As to what law is going to apply. And it happens. It's constant. There's always the amount of conflicts among the DCAs are astronomical.
Yeah.
It's not like it's a rare event. I would say for any issue that you're going to pick, there's like a 75% chance that at least one of the DCAs is going to be completely off the reservation on the issue compared to the others. And it could be, and it depends on where you are. Like,
and if you're in that DCA, then you're on that path. You're following that law.
Now, there's one other thing that I will say. We haven't mentioned this yet, but
okay.
To resolve conflict, there's one other way to resolve a conflict, and that is if you lose an appeal, you can ask for a rehearing en banc.
Ooh.
Because
so which one of your banks was that? Was that Bank of America? First National Bank?
ENBANCK or EN space BANC en banc. It's Latin. I don't know what it means. You probably do, Pat.
I speak English.
Okay. But what that means is it's usually denied. But what it means is if, and I have had this happen a few times, where the district court will say they'll take a poll among all the judges of the DCA, and let's say there's 15, then all the judges say yes, we want to hear this en banc. We want to, because we think our DCA decided it wrong, and we agree with this other DCA, or we don't like what the panel below us just did. We want to undo that, and I've seen that.
Yeah.
There's a big case in the third DCA called Bouvet, BEAUVAIS, on the statute of limitations, and the third DCA, the bank moved en banc and said, we don't like this panel opinion. There was 3 judges that decided it of the third district court of appeal, and the entire third district, all the judges sat with, like, I forget how many there were across, on the podium, and they listened to the oral argument again and completely reversed what the 3 judges had done.
Wow.
Now, the 3 judges that decided the original case, they dissented, but there was, I think, 6 of the other judges, I think 6 out of 10, or 7 out of 10. No, I think there was 4, I think, that dissented. So there were 6 judges, and they said, no, we're gonna go with 50 CA on this, and we're gonna reverse what the panel did. And that's another way that conflicts can be undone. And what the case law is that one 3-judge panel of a DCA is not supposed to disagree with an earlier panel of a DCA. They're supposed to follow the earlier panel.
Right, just as that is case law precedent for lower courts, such as trial courts, we're supposed to be following that precedent within the District Court of Appeal. Stare decisis, right?
Right.
Yeah.
And unfortunately, that doesn't happen a lot. I mean, a lot of times you just do whatever they want. They'll try to distinguish it, say it's different for this reason or that reason. The car is blue in this case, instead of red, some distinction without a difference, but they're supposed to follow that earlier panel.
Right.
Or go one block.
Yeah. Well, with that, let me bring us to a slightly different topic, but still on the topic of the Supreme Court of the state of Florida. Let me take a look at Article 5, Section 15. That's over here on my shoulder. That talks about attorneys, admission, and discipline. So, Section 15 says the Supreme Court of the state of Florida shall have exclusive jurisdiction to regulate the admission of persons to the practice of law and exclusive jurisdiction for the discipline of persons admitted. So that's when I'm defending my fellow lawyers against bar grievances and ethics complaints. Those always start at the Florida Supreme Court. Florida Supreme Court doesn't take testimony directly. They will appoint someone to do that. They will appoint a referee. That referee is usually a sitting county or circuit court judge who will actually hear the witness testimony and prepare a report of referee with findings of fact and recommended conclusions of law when it comes to discipline. But the final say remains with the Supreme Court of Florida. If you're applying for admission to become a member of the Florida Bar, you'll start with the Florida Board of Bar Examiners, but ultimately it is the Supreme Court of Florida that's going to decide whether you're a member of the Florida Bar. So that's what we're talking about here. And I wanted to give everybody a chance to participate a little bit. And why not? Because the technology has been absolutely flawless so far, hasn't it, Mike?
Absolutely.
I'm trying to make light of a situation. Thank you, everyone, for bearing with the technical flaws that we're suffering. I've got 7 business days to iron them out and fix them all for next week. And I promise you I'll make a dedicated effort to get that done. But you might want to buzz in, so to speak. So I've got a method for you to do that. It's very simple. You can use any internet connected device. You're not required, but if you'd like to, you can. Just type what you see here, which is www.pollev. It's an abbreviation for poll everywhere. It's 6 letters, POLLEV.com. So pollev.com, and then /P McGinley 553. That's P as in Patrick, my first name, McGinley, McGinley, my last name, and then the numbers 553 that were randomly assigned to me. I swear they have no relevance to me. I didn't pick them. If they're somehow derogatory, don't associate that with me. Mike, is that a gang? Is there maybe the 553s out there? I'm not a member of the 553s. If such a gang exists, I don't know. But if you go to that site, you should be able to see, not this slide, but the next one, the question I'm going to ask. And Mikey, you can play along too. Let me read the slide to you. Sound good, buddy?
Sure.
All right. So here's the question. I'm talking about Article 5, jurisdiction of the Florida Supreme Court, and how it has exclusive jurisdiction over attorneys and the admission of lawyers. So here's the hypothetical. I just had to pick a name. I picked Johnny. John's my middle name. Johnny never went to law school, Mike. You know those tuition payments we eventually paid off? Johnny never went to law school. He wants to call himself a patent agent. But here's the problem, Mike. Johnny flunked the patent bar exam that's given by the United States Patent and Trademark Office. So Johnny never went to law school, and he flunked the patent bar exam. The United States Patent and Trademark Office, the USPTO, if you will, they hire him as a patent examiner. 4 years later, he quits that job. And then following the rules for former patent examiners that you can find if you'd like at 37 CFR section 11.8, he obtains the title patent agent. Now this title he got by following the CFR, the Code of Federal Regulations, that's the same title he would have earned, Mike, if he hadn't flunked the patent bar exam 4 years earlier. But he's got it now. He then, with this title on his business card, moves here to the sunny state of Florida. He opens his own office right here in the state of Florida. He advertises right here in the state of Florida. He gives legal advice to patent applicants that are right here in the state of Florida. He drafts up their patent applications. These are not his own applications for patents, Mike. These are his clients' applications. He's drafting those. He then meets with and argues with the United States Patent and Trademark Office, the USPTO, not about his own patents, but about the denials of his clients' patents. Yeah. So here's the question for you, Mike, and for anyone else who wants to play along. Start the presentation to see live content. I don't think this part worked either. Oh well. Hope this part works next week too. Y'all, I hope you're a forgiving bunch. But anyway, so that's what I wanted to ask is, can the Florida bar shut down Johnny's office? Mike, looks like you'll be the only one buzzing in. Sorry to the other 49.
I know that in certain administrative agencies, people can practice and represent other people without a bar license. And I think that's true in Social Security cases. And with patents,
it's also true. You are
is it
correct.
also true?
You are correct, Michael Starks. And why is our guest star correct today, ladies and gentlemen? The reason he's correct is because some of us call it the unlicensed practice of law. Properly, the better terminology would be the unauthorized practice of law. Because as we know from our hypothetical, the Code of Federal Regulations authorized Johnny to do what Johnny is doing. Now, all of you listening, you remember lectures number 1 and 2, and Mike, you know this very well too. When federal law says you can do it, and you follow that federal law, can you do it?
Yeah, I would guess.
Yes, you can.
It's federal preemption, I would imagine.
Thank you very much.
I know before I went to law school, I was thinking about just getting a paralegal degree and representing people in front of the Social Security Administration. That's why I do that.
Yeah, and you could follow that rule. And those of you out there who somehow don't pass the bar exam, God forbid, that is an option. So let me go to the next hypothetical. Mike, you haven't gotten a single question wrong yet. I know you'll come through for us again. Are you ready?
I'm ready.
All right, next hypothetical. This one's about Sally. Sally never went to law school or college. Some people don't. She dropped out of high school, but now she has a GED. Good job, Sally. After meeting the requirements of the United States Internal Revenue Service, also known as the IRS, she's given the title enrolled agent. Mike, have you heard of those enrolled agents?
I have.
I've had one do work for me once. Brilliant people, well-trained people. And indeed, Sally has earned the title of enrolled agent awarded to her by the IRS. She moves to Florida. She opens her own office. She gives advice to clients about how to minimize their future tax bills. When clients are audited, she meets with the IRS on behalf of those clients and she argues for them. She then appeals within the IRS if her arguments are rejected. If that fails, Mike, do you know what she does then?
I know.
She uses her membership in the United States Tax Court to draft a complaint, file it, and sue the Internal Revenue Service, the IRS. She sues them on behalf of her clients. Here's the catch, Mike. Sally is not licensed to practice law in the state of Florida. Question. Ready, Michael?
I am.
Can the Florida bar shut down Sally's office?
I'm gonna say yes, Pat, on this one.
I didn't hear you. You were gonna say no.
No.
You were gonna say, and you are correct. The Florida bar cannot shut down Sally's office.
That's right.
Cannot.
Absolutely not.
Why is that? Well, the Internal Revenue Service has awarded her the title enrolled agent. Remember, it was better phrased as the unauthorized practice of law, not the unlicensed practice of law. The Internal Revenue Service has authorized Sally to do all the things that she's doing there. So, Florida bar doesn't have jurisdiction. Supreme Court of Florida, despite Florida's Constitution, doesn't have jurisdiction. What we have here as a conflict, if you will, between the Florida Constitution, the highest expression of state law, and a rule and regulation of a federal agency. Do you remember class 1? Do you remember lecture 1? Do you remember that hypothetical? I asked you that. Do you remember your midterm? This question was on there. I asked you that. And the answer is federal preempts. Federal prevails. This is the authorized practice of law. So the last question is, who owes more in student loans, you or Sally?
I don't know any now.
Hey, me either. But, we're talking to some law students here. I bet more than one is taking out a student loan. Am I right, people?
Yeah.
There
It
you
took me
go.
23 years.
Hey, probably roughly the same for me. So there you go.
And I don't know if you're going to get to it, Patrick, but are you going to talk about how our judges get an office? Is that something?
Yeah, absolutely. Okay. But I'm looking at the clock and it's 6:50. I'm a little past time for our break.
Okay, sure.
Yeah, I'm trying to make this distance learning class as close to the real class as possible. And hey, with all these technological problems, that's probably pretty close to what would happen in real life anyway.
Right.
But anyway, we always take a break when we meet in person, so it just makes sense to do that in a virtual class. Mike, I usually throw it out to the room, but you're the only one who probably would be able to answer me right now. How many minutes break should we take, Mike?
I defer to you, man.
How's 7 minutes sound?
Sounds good.
I got 6:51 on my clock. I'll see everyone back at 6:58. Sound good?
Sounds good.
All right, Mike, I'm going to take you with me. Unicorn, I'm going to leave you here. All right, see you all in 7 minutes. Now, Madeline, we're on a 7-minute break, so I'm not sure how many people are still. It says 48, so there could be people who can see you. Hey, everyone. I don't know who's still watching. We're still on a break. I haven't come back from break yet. This is Madeline Marie McGinley. How old are you, Maddie?
7.
She's 7. She's our beautiful daughter. But something very exciting just happened. She'll open your mouth to everybody. She lost another tooth. Look at that. All I want for Christmas is but 2 front teeth. Congratulations. Were you at Park Avenue Pizza when it came out?
Yeah.
You were?
So like I finished most of the pizza, but when I tried to eat the bubble, then there was only one part of the gum hanging, and then I took a napkin and pulled it out.
You pulled it out? You pulled it out. Patrick, is it true? Did you pull it out?
No,
It's
Yeah.
true. It's true. Hey, come on over here.
I
Oh, the
didn't
wires.
see
The
it.
wires. Sorry about the wires, but can you get under the wires? Yeah. Hey, Patrick's back. There you go. So let me see it again. Let me see. Oh, that's wonderful. How close can you get? Oh. Love you, Madeline. That's so cool. So you saved the tooth, right?
Yes.
Oh yeah, this tooth fairy's coming. Y'all want to tell the good folks out there how much the tooth fairy's been paying lately for teeth?
I don't remember how much.
$5.
$5 for a tooth. Tell you, Madeline, when I was a kid, it was a nickel. A nickel. So I guess prices go up, right, Patty?
Yeah.
Yeah. So, oh, a glass of water, thank you.
Patty, I hear the alarm for your chess game.
Oh,
Okay.
Yes.
Come on, Maddie, move.
All right.
All right, we got 2 minutes left in the break. See you in 120 seconds. Madeline, are you still in there? Madeline, have you been here the whole time? You have? What have you been doing? Are you taking your unicorn?
Oh,
Okay.
it looks so cute on YouTube, the unicorn.
Oh, did the unicorn look good?
Yeah.
Yeah.
Oh, honey, Daddy needs that, okay?
Thank you, Madeline. Oh, another one. Thank you.
Hey, Patrick,
Hey, Mike.
do you think they can hear me, or do you think they're getting anything out of it? Or?
They're hearing you right now. You have a very accurate clock, man, because I think, yep, 6:57. So, welcome back. So I dare try the tech again. Try to get you on the screen.
That'd be great.
Yeah, why not, right? So embarrassing the tech doesn't work.
Well, it's not your fault. We had a huge virus pandemic.
I'm glad to know that. I was afraid I might be blamed for the virus pandemic. That would be unfortunate. Good. Hey! You're sideways, but you're there.
Should I turn? What if I do this?
Undo whatever you just did, please. Shucks. Hold on.
What happened?
There you go. All right. Yeah. You know, I wanted there to be some comedy in this episode. I guess I succeeded on that, right? All right. Welcome back, everyone. Welcome back. Hope you had a nice break. The kids were here. Mike, you missed this part, and probably most of you did too. But during the 7 minutes, my family came home, and Madeline lost another front tooth.
Wow.
Well, there you
I know
go.
what she wants for
For
I know what
Christmas.
she's gonna get for Christmas.
Yeah, yeah. Oh man, I just dropped the iPhone. Hey, the screen didn't break. There we go. Let me switch back to the slides. All right. Hey, this is really comedy. Huh? I became a lawyer. I should have been a comedian at this. All right. Well, Mike, you had a great topic for us to cover. Is how does a judge become a judge? I've got some slides on a different topic, but I do love that question. So why don't we cover your topic first, Mike? Sound good?
Yeah, sure.
Yeah.
You want to start, or you want me to start?
Yeah. Oh, and let me clarify. I gave out that poll everywhere, pollev.com, a website. That's not working either. So I apologize for that. I see in a live feed somebody's struggling to log on there. Don't try it this time. We'll do that next time. Hi, Madeline. Do you miss Unicorn? Do you want her back? All right. She wants Unicorn back. Here you go. Thank you. All right, Mike. We're unicornless.
All right, cool.
All right, there you go. So, Mike, how's a judge become a judge?
Well, they run for office. Is typically how it's done. It's interesting because the election rules for them are very different. As a matter of fact, if you get bored, you go on Westlaw or Lexis, and there was a judge that ran in Seminole County back in the 90s named Nancy Alley.
Oh, I should clarify. We only plug Westlaw here.
Well, that's the best. Westlaw's the best. But she got hot water for election stuff. And matter of fact,
hey, welcome back, everybody. Mike was talking about a judge that got in the hot water for election stuff. Mike, our video feed cut out for a second.
She basically accused her opponent of doing what she did, which was being a public defender and some other things. And the Florida Supreme Court actually, and this is actually listed, Patrick, on in your discussion of things that only the Florida Supreme Court can do. One of them is to decide JQC complaints, which is the sort of the same as the bar for the lawyers.
Yeah, JQC stands for Judicial Qualifications Commission.
Right. If you're a judge and you do bad things, the bar doesn't get you. It's the JQC that gets you.
And then when the JQC takes away your right to be a judge, then the bar comes after you.
Exactly.
Because now you're a lawyer who was a disjudged judge. They'd like to turn you into a disbarred bar member.
But the reason I bring that up is because it's interesting because back in the 90s, the Florida Supreme Court was bound by the Florida Constitution to follow the recommendations of the JQC. And in that case, in Nancy Alley's case, the JQC had said, we don't think she should be removed from the bench. We think she should just get a public reprimand. So when in the opinion, the Florida Supreme Court said, well, we were in this case, we are constrained to follow the JQC's recommendations of just giving a public reprimand, but we find it hard to swallow that someone who benefited by election misconduct would remain in office. And the Florida Constitution has now been changed, so the next judge that does what she did is going to get kicked from the bench, which did happen. They did a different judge. They ended up actually kicking him off the bench. But so basically, the judges run for office just like any other person that runs for office, but they are constrained to what they can say. They can't really talk about politics. They don't really run as Republican or Democrat. They can talk about their experience, qualifications, but they're more constrained as to what they can say in their ads. But if they're elected, they get elected for 6 years, which is the longest term in Florida, and that goes for county and circuit. But then, of course, if they die or they become ineligible or they get removed from office for misconduct, then the governor will appoint a successor who will then stay in that office. I believe they have to be ratified by the Senate, but then they stay in that office until the next election. Then they have to run. Yeah, I think that's correct, right, Pat?
That is absolutely correct. Also, in addition, let's talk about justices of the Supreme Court and the judges of the District Courts of Appeal. Now, to get that job, you are nominated by a JNC, Judicial Nominating Commission. This consists of both lawyers and non-lawyers. The governor then chooses from the JNC list. So governor can't pick a buddy or a friend unless that buddy or friend happens to be on the final list submitted to the governor by the JNC. The judge or justice then becomes a judge or justice of that court and is then in the next election, we ask whether that judge or justice shall remain in that position. There is no opposing candidate and there's no party affiliation listed with the judge. So it's a nonpartisan and it is a yes or no vote. Shall Justice so-and-so remain on the Florida Supreme Court? Shall Judge so-and-so remain on the District Court of Appeal? And Mike, with these types of elections, these yes or no votes, can you tell me how many judges or justices have lost their job because the majority said no instead of yes?
Zip. Not a single one.
That's right. Zero. Nada. So I guess
they don't know the judges, and they will. And this has been in the face of concerted efforts. For instance, the conservatives led a very vigorous campaign to unseat Justices Periente, Quince, and Lewis off the Florida Supreme Court. and it failed. There have been others attempts to do the same thing, and they've all failed.
And a lot of money can be spent on these attempts, but so far, none of these attempts have unseated a sitting judge based on one of these yes or no retention votes.
Right, which is, you know, and to go back to Alexis de Tocqueville, when he talked about that there was no separation between the people and the judges, and that he was concerned about tyranny of the mob, where, you know, legislators are elected by the majority, governors and other officers are elected by the majority. He was concerned that the judges were also elected by the majority, unlike in the federal system where they're appointed. But in Florida, we have sort of a happy balance where basically, like what you're saying, Patrick, it's never been done. So for all practical purposes, once you're a DCA judge, until you age out, in other words, you get too old, you got basically a life on the bench.
Yeah, and that's the reality of it. Yet that's how Florida's Constitution says to do it. So that's how it's going to be done with these yes or no retention votes.
But the interesting thing too, Patrick, is they just changed it. You know, it used to be 70 years old, and now it's 75 for judges is the mandatory retirement age. And the interesting thing is, I just mentioned Justice Perriente, Quince, and Lewis. Now, those were the three that left after Governor DeSantis got elected. And he, of course, appointed three replacements. I think it's Mnuchin. Is that how you say it?
I think so.
He was an officer with the Attorney General. And then there was third DCA judges, Luck and Lagoa. And then Luck and Lagoa were on the Florida Supreme Court for just a few months, and then President Trump put them on the 11th Circuit. So now I think we now have only 5 Supreme Court justices on the Florida Supreme Court right now. I don't think they've been replaced yet. Justices Luck and Lagoa haven't been replaced yet. I do not believe. And the interesting thing is, of the JNC list, remember you mentioned the JNC, Judicial Nominating Commission. I've seen the list that was sent to the governor, and I think it's like 15 judges, and or either there's like one judge in Lee County that's he's a circuit judge. Actually, he's a brother of a guy we went to law school with, Patrick, Keith Kyle. We went to law school with him. His brother is Bruce Kyle. He's on the list to go on the Florida Supreme Court. And then there's a few, but one of them has to be from the 3rd District, because I think you have this in your book, Patrick, that at least there has to be one justice on the Florida Supreme Court from each of the 5 districts.
That's right.
So one of them has to be from the 3rd DCA.
Yeah.
It has to live in the 3rd district.
Mm-hmm.
But anyway, that's how the judges. And I think to get removed, it has to be for cause, Patrick. Correct me if I'm wrong.
They have to be impeached?
I don't think they use the term impeached, but the governor can remove them for cause. And I have to look at that to see exactly. But they can be removed for serious misconduct.
Yeah. Well, Mike, this has been an extraordinary discussion. How about we discuss some extraordinary writs?
I'm all over it.
Did you like the segue?
I did. It was good.
Thank you. This is an extraordinary segue. So let's talk about extraordinary writs. So in general, extraordinary writ is an original action that is filed in an appellate court. It's following the Florida Rules of Appellate Procedure, and you're drafting a petition that looks a lot like an appellate brief. So this is not an appeal that follows a trial. This is the start of your lawsuit. The extraordinary writ is a petition that is filed, and it is the beginning. It's an original action. One extraordinary writ covered in our book, and the first covered there is a writ of mandamus. Like that one, Mike, the writ of mandamus?
That's a good one.
Yeah, the writ of mandamus is a petition for a writ. It is seeking a remedy for the government's failure to do something that the government is supposed to do. Now, in order to succeed on a petition for writ of mandamus, you've got to have a clear legal right to the performance of a clear legal remedy. So what you have here generally does not involve disputed issues of fact. By nature, the fact that you've got to show that you have a clear legal right to a clear legal remedy. Likewise, this action, which generally doesn't involve disputed issues of fact, does not generally involve disputed issues of law. By nature, the fact that you have to have a clear legal right to a clear legal remedy. If the law that you're trying to rely upon is not clear, then you're not going to meet your standard of showing a clear legal remedy. Likewise, you might have to show some facts. You might have to include an affidavit. You might have to include a deposition. You might have to include some admissible evidence as part of the appendix to your petition for writ of mandamus. But ultimately, that has to be an undisputed fact, or you're not going to satisfy the burden of a clear legal right. So that's what we're talking about when it comes to a writ of mandamus. So when might you use a writ of mandamus? Well, when the government is lacking and failing to do what the government is supposed to do, then you might turn to the extraordinary writ of a writ of mandamus. Now, why do we call these writs extraordinary? First and foremost, we call it that because they're original actions. They are not appeals that follow a trial or a trial court proceeding. The second reason we call them extraordinary writ is they are granted at the discretion of the court. Unlike most times when you go to court, most times, if you prove the elements of the action, then you are entitled to relief. With an extraordinary writ, you might prove all the elements of your action, but it still remains in the discretion of the court as to whether or not to grant you the relief. That's extraordinary, and it's an extraordinary writ. Next one I wanted to talk about, Mike, was a writ of prohibition.
Can I just add one thing about mandamus?
Please.
Yeah, the writs of mandamus, they're always targeting a government official. They're not.
Right.
You don't bring a writ of mandamus against a citizen.
Very good point.
But the key issue is that there's got to be no discretion in the act. So, for an example would be where the clerk is supposed to, in a regular appeal, transmit the record to the appellate court.
Yeah.
They're supposed to take what's in the rule, the pleadings, the transcripts, that kind of thing, and anything the parties tell them, and bait stamp them and number them. R1 through R. R stands for record.
Very
R1
clerical,
through R2000.
non-discretionary task you're describing there, Mike.
Right, and they're supposed to. Then it's what I would call, just basic stuff that anybody could do. So they're supposed to then send that up to the appellate court. If the clerk doesn't do that, then you could get a writ of mandamus against the clerk, most likely, and the court would say, "Clerk, please do your job and send this record to the appellate court."
Yeah, because
that's an example.
Your example is a perfect example of a government's failure to do something it's supposed to do. You had a clear legal right to the performance of a clear legal duty. Yeah, great example for a petition for writ of mandamus.
And there's a pretty famous case that came out about a couple of years ago where the clerks were backdating in Broward County. Were backdating documents because they were, like you said, they're underfunded. They don't have enough people to do their jobs. So things were getting filed, and they were basically backdating them to when they should have been docketed as opposed to when they were actually docketed.
Wow.
So you might get a docketed document that you, like I say, let's say an order, you have 30 days to appeal, but when it gets docketed, the clerk is docketing, it like 45 days in the past, which basically screws you out of your appeal. Because 30 days of, there's a difference of 30 days or more. Yeah. So I don't remember if the 4th DCA issued it as a writ of mandamus or not, but I remember them very strongly saying, Broward County clerk, stop doing that.
Yeah.
So that's an example of when a writ of mandamus would lie.
Yeah, I like that. It's another great example. And in our text, we give 6 required elements for a writ of mandamus. First, the petitioner has a clear and certain legal right. Second, to the performance of a particular duty. Third, by a government or a representative of the government. Fourth, whose performance of that duty is ministerial and is not discretionary. Fifth, who has failed to perform despite an adequate request. And sixth, who has left the petitioner with no other legal method for obtaining relief. So prove those 6 things and you'll be well on your way to getting this extraordinary writ. And Mike, you've got just a few minutes left with this because my battery's dying.
Okay, no worries.
All right, let's talk about a writ of prohibition. Writ of prohibition is also an extraordinary writ. It's also an original action. It is also relief that is discretionary. It is an original action filed with an appellate court seeking a discretionary remedy to prevent a lower court or tribunal from improperly exercising the lower court or tribunal's judicial power. Prohibition is that process by which the superior court exercises its discretion to prevent the inferior court from exceeding the inferior court's jurisdiction in matters over which the superior court has cognizance. That's the use of the writ of prohibition. If it's granted, then the writ of prohibition is an enforceable command from the higher court directed to the lower court or tribunal, preventing it, the lower court, from performing certain acts. There's 5 required elements of a writ of prohibition. First, you've got to have an inferior court or quasi-judicial tribunal. Second, that inferior court or quasi-judicial tribunal will make or avert an unauthorized use of its judicial or quasi-judicial power. Fourth, that will cause the petitioner harm for which there is no other appropriate adequate remedy. And fifth, therefore, the reviewing court should exercise its discretion to stop this harm from happening. So, Mike, you can see there, this is something you've got to file before the harm happens. Do you see that, Mike?
I do see that.
Yeah. And the third, go ahead.
Go ahead.
No, please.
Well, I was just going to give you an example.
Please, sounds great.
So, and it's kind of the writ of prohibition is the flip side of the writ of mandamus. Writ of mandamus is do something. The writ of prohibition is don't do something.
I like that.
And so, but with the writ of mandamus, the writ of mandamus can be directed to a court, but it can also be directed to a clerk or a governor or someone that's got a specific duty they're not doing. It's got to be a ministerial duty, meaning it's clearly defined and you don't have any choice about it. There's no exercise of discretion. Writs of prohibition, on the other hand, are more broad, but the target audience is smaller. It's typically a court, a lower court. And the way that I have seen writs of prohibition in my career is typically it's when the judge does something or is related to somebody or knows somebody, like they play golf together, whatever, and you file a motion to disqualify the judge for bias. And there's rules about that. You have 10 days to do it when you find out about the bias, et cetera, et cetera. And but if the judge denies your motion and you don't think it's appropriate, then the way that you get the appellate court to tell the judge to get off your case is to go for a writ of prohibition. And I did that in a case. It was a case where I was representing the city back in the day, city of Altamont Springs, and the judge made some really bad comments about
I met my wife in that city.
And my client. What's that, Pat?
I met my wife in that city.
Yeah, it's a great city.
Great
and
city.
So the judge made a bunch of comments about me and my client. I was running around in diapers. I was a year out of law school.
Sorry to hear that.
Counselor, you're going to dazzle me with the law, stuff like that. So all this is on a transcript. So I sought a writ of prohibition. Fifth DCA granted the writ of prohibition, told this judge, get off this case.
Wow.
And let another judge, hear this case. And they also referred him to the Florida Judicial Qualifications Commission. And he ended up getting a public reprimand about what he did to me and also a few other people.
Wow.
In the case. So
hey, sorry that happened to you, man, but the story had a happy ending, I guess.
Yeah, it did.
Yeah.
It did. He ended up actually resigning from office in sort of disgrace. It was kind of interesting, but I won't go into all that. But anyway, but go ahead, Patrick. That's a writ of prohibition.
Yeah, great example. Thank you. Next writ I was going to talk about was the writ of quo warranto. Now, I already said I don't speak Latin, but my understanding of the translation of the Latin quo warranto is whose authority. So this is a writ of whose authority? The writ of quo warranto. It's an action to challenge the exercise of some right or privilege, the peculiar powers of which derive from the state. So the person you're seeking quo warranto against most likely will be the state or a state actor or a government actor, but it need not be. It's any person who you're saying doesn't have the right to exercise a particular power that derives from the state. So here's the 4 elements then for a writ of quo warranto. First, you got to have a Florida official, a government agency, or another alleged recipient of a power or right that's derived from the state of Florida. Second, that individual has or will exercise this power that's derived from the state of Florida. Third, such use is or will be legally improper. And fourth, therefore, the court should exercise its discretion, again, discretionary relief, discretionary remedy, exercise its discretion to grant this writ of quo warranto. So, Mike, that's what we're talking about with the writ of quo warranto.
Can I give an example?
Please. You're doing great.
Really good examples in your book, and it starts at page 211. A very interesting case, Florida League of Women Voters of Florida versus Rick Scott. Now, remember we mentioned Justices Perriente, Kent Quince, and Lewis, the three liberal members of the court that conservatives have been trying to get out of office forever. Well, Governor Scott, on his last day in office, was going to appoint three successors that are conservatives. Well, the Florida League of Women Voters brought this writ of quo warranto to try to stop him from doing that. And the Florida Supreme Court, in this opinion, which is in the book, I think it's the full opinion, said you can't issue the writ because the harm had not yet occurred. In other words, Governor Scott had not yet appointed the three replacements. And if you notice, it's LaBarga, Chief Justice, Canada, Polson, and Lawson, who were the four justices that agree with that. And then Justice Quince concurred in result only, with whom Justice Perriente concurred, and then Justice Lewis wrote a dissenting opinion. But anyway, so the court said no quorum warranto on that. No quorum. I can't talk. No quorum.
It's okay. It's Latin. It's not even English.
But I'll give you real quick another example. Typically, the quo warranto, and I know you said it could be anything, but typically it's involved with elected officials or officials, whether they can do certain things. But typically it's elections.
Yeah.
That's where you see it. I see it a lot. And so I had a case where there was a school board member that was running for office, and she was challenging our client who had set up a room that he was renting in the district to be able to run for school board in Seminole County. And she was saying this was improper, that it was just a room, it was just a ruse, a trick, etc. And the incumbent who was fighting us, Nancy Warren was her name. Her lawyers were seeking an injunction. So we argued to the Seminole County Circuit Court and said that the proper remedy, that first of all, you can't get injunctive relief when there's an adequate remedy at law. You have to get the legal remedy, and you can't get an equitable relief unless there's no legal remedy. And there is a legal remedy, and that legal remedy is the writ of quo warranto. Nobody had heard of it. I stumbled upon it by pure accident, and we argued that, and it was like a few days before the election, and the judge said, yep, that's right. Legal remedy is the writ of quo warranto. That's what you should have gone after. You didn't go after it. Case dismissed.
See that?
And
so taking a class like this and hearing about some extraordinary writs can really pay off in real life. How to get that plug in there?
They had a huge effect in this case.
Yeah.
So that's my writ of quo warranto example.
Love it. Love it. I got some notes and questions to consider in the textbook under the case that you just covered for us, buddy. League of Women Voters versus Scott. Mind if I throw a few of those at you?
Sure, go ahead.
All right, I'm on page 218 if you're reading along. Notes and questions to consider. Number one, the majority rules that the writ of quo warranto is not available until after the respondent acts, which is what you pointed out to us, Mike. Well done. The respondent's stated intention to act is insufficient. What's the advantages and disadvantages of that?
Well, if you got to wait till the damage is done,
right?
You know.
Yeah. Note two, facts of this case involved an incumbent chief executive, his desire to fill a Supreme Court seat, and an attempt to keep the seat open until the incumbent was replaced by his successor. Are not those the same facts that fairly recently occurred on the national stage? In March 2016, outgoing U.S. President Barack Obama nominated federal appellate judge Merrick Garland to fill a vacant seat on the United States Supreme Court. But the United States Senate, led by Majority Leader Mitch McConnell, successfully prevented Judge Garland's appointment and kept the seat open for the incumbent president to fill. Would the result have been the same if this played out in Florida instead of on the national stage?
Well, in essence, you have there the flip side,
Yeah.
the opposite.
Yeah.
And, because.
And I like to do that in this class.
Case,
I like to compare and contrast federal law with Florida law, federal constitution with Florida constitution. So forgive me for doing it yet again. Every time I end up doing that, it gets me into politics. And there's always somebody who's mad at me when I talk about politics.
Yeah, I understand. But it's sort of a reverse situation. In that case, they were trying to keep it open for the next guy. And in the case of the Florida Supreme Court case, Governor Scott was trying to replace him when he was still in power and not leave it to the next guy because he didn't know who the next guy was going to be. You know what I mean? He didn't know if it was going to be Gillum or if it was going to be DeSantis. He wanted to get those guys in. And they ended up, of course, being replaced by conservatives, so it was kind of a moot point. But of course, he didn't have a crystal ball at that time.
Right.
But it's sort of the flip side of it.
Yeah,
but it is interesting that you point out that almost the exact same kind of thing.
I try to come up with interesting stuff in this book. I don't know that Florida's constitution is inherently interesting, so I try to come up with things that are interesting. Note 3. 3 of the justices deciding this case are the justices that the governor intends to replace. Although technically this may not have caused a conflict of interest, did it not place the governor and his counsel in an awkward position? What do you think? Would you feel awkward, Mike, arguing this one?
And everybody knew what was going on.
Yeah, everybody knew.
There was no.
Yeah.
There was no. Right now, I mean, as a court. Well, of course, right now we only have 5 justices, but when Governor DeSantis had replaced those 3, Lewis, Pariente, and Quince, then basically there was 6 conservatives on the court at any one time. Of course, that wasn't that didn't sit well with the Democrats. But it's the kind of thing where it's interesting because, and we talked about recusal earlier, when a judge is biased or whatever, but the rule is very different for appellate judges. It's the same whether it's an appellate judge for a circuit court sitting in a appellate, with a 3-judge panel or a DCA or Florida Supreme Court. Basically the rule for appellate judges is they do what they want to do. If they don't feel like they're biased, they don't have to recuse themselves. It's a very different rule.
Very different. And with that, let me move to another extraordinary writ. Now I'm on page 220, and I'm talking about here another extraordinary writ called the constitutional writ, sometimes just referred to as the all writs power. What we have there is that events transpiring now or in the future may sometimes affect a court's jurisdiction. Florida law provides this limited means to proactively thwart such events. So this is a constitutional writ. This is the court's all writs power. It's an original action to preserve a court's jurisdiction that has either already been invoked or protect a court's jurisdiction that will likely be invoked in the future. The elements are as follows. Here are the 3 elements. 1, the court has jurisdiction now or is likely to have such jurisdiction in the future. 2, events are transpiring that are a threat to the court's jurisdiction. And 3, the court should exercise its discretionary authority to protect its jurisdiction. So exciting, right, Mike?
It's a very important writ.
Oh.
And it's one that I deal with a lot.
Okay.
And this is what you hear people say, motions.
Oh, I know whatever Mike was about to say was brilliant. I warned him the cell phone battery was soon to die, and indeed it did. So that also means not only does Mr. Starks leave us, but so does Unicorn. Everyone, please say goodbye to Unicorn. Okay, Unicorn's gone. Now, forgive me for just a second while I move the camera because I want you to be able to see the slides over my shoulder just a little bit better. So sorry about the jarring picture for a moment. Bear with me. Here we go. All right, there we go. Hopefully you can see the slides a little bit better this way. Since we don't need to see Mike, I can alter the picture. So last writ we wanted to talk about. Now I'm on page 221, and over here talking about the writ of certiorari. Now, there's been a lot of articles written joking about the pronunciation of this word. Personally, I go with certiorari. You might go with certiorari, certiorari. Most practitioners will simply say cert. Writ of cert. Indeed, in the law review called Green Bag, there's a humorous survey of United States Supreme Court justices and the lengths they have gone on the record to avoid saying the word certiorari. So if you can't say it well, you are not alone. If you want to avoid trying to pronounce it, you are not alone. I'm going with certiorari. I'm referring to Certiorari. I hope that I'm pronouncing that in a way that's acceptable to you. So what is a writ of certiorari? Writ of certiorari is a special mechanism by which a superior court, under quite limited circumstances, can review something. Now, think of it this way. Usually, an appellate court reviews something on appeal, by which we mean judicial labor has ended in the lower tribunal, and now the appellate court is reviewing the lower tribunal's acts to see if there's been a preserved error that was harmful and that warrants reversal. This is the typical way of things. But sometimes we just can't wait. We just can't wait until judicial labor has ended. Sometimes we want the appellate court's intervention now. That typically is the use of a writ of certiorari. So, for example, say that you are a company such as WD-40. I don't know much about WD-40, and my facts may be out of date, but as far as I know, they don't have a patent for the secret formula for the WD-40. It is so secret, as far as I know, that they didn't even want to share it with the United States Patent and Trademark Office. Imagine, if you will, that WD-40 is involved in some litigation. Every corporation eventually is involved in some litigation, and a discovery request is made for the secret recipe for the WD-40. You would hope that the trial court would understand that that's a trade secret and should not be shared with the plaintiff. But what if the trial court errs? You can't unring the bell. You can't put the cat back in the bag. You can't undo the fact that the secret formula has now been revealed. You've got to get the appellate court involved right away. That would be an example of a use of a petition for writ of certiorari. But the petition for writ of certiorari, is that something that can be heard by every court in the state of Florida? That's the question I want to address with my slide here. Look at the jurisdiction of the Supreme Court of the state of Florida. And again, you might hypothetically put supreme in quotes, not out of disrespect, but to emphasize the limited jurisdiction of our state's highest court. Here we see in Article 5, Section 3, that the Supreme Court has jurisdiction. It may issue writs of prohibition to courts, and it may issue all writs necessary to the complete exercise of its jurisdiction. So when it comes to those extraordinary writs that we talked about earlier, the writ of prohibition and the constitutional writ, the all writs power, Supreme Court of the state of Florida certainly has jurisdiction to issue such writs. But what about the other writs? Look at the limitations that this Supreme Court has put upon it in Article 5 of Florida's Constitution. The Supreme Court of Florida may issue writs of mandamus and writs of quo warranto to state officers and state agencies. What does that mean? If you're looking for a mandamus or a quo warranto against someone other than a state officer or a state agency, the Supreme Court of Florida lacks jurisdiction to even entertain that petition. So what if you want quo warranto against the mayor? What if you want it against a local official? You can't go to the state of Florida Supreme Court because the Supreme Court of the state of Florida would lack jurisdiction. Supreme Court of Florida may, or any justice may, issue writs of habeas corpus, returnable before the Supreme Court or any justice, returnable before a district court of appeal or any judge therefore, or any circuit judge. Did you notice a writ absent from the list? How about certiorari? Where is the jurisdiction of the Supreme Court of Florida to grant a writ of certiorari? And think about that. The Supreme Court of the United States, can it grant a writ of certiorari? Yes, the Supreme Court of the United States certainly can. Indeed, more than 90% of the docket of any given modern year of cases before the United States Supreme Court are there before the U.S. Supreme Court based on a petition for writ of certiorari. So the U.S. Supreme Court can and does entertain petitions for writ of certiorari. Can the state of Florida's High Court, the Supreme Court of the state of Florida, entertain a writ of certiorari? And the answer is no. No. The Supreme Court of Florida lacks authority under Florida's Constitution to grant, deny, or even consider a petition for writ of certiorari. Why is that? And the reason why that is, I will share with you, because it will help you remember. Why is it that the Supreme Court of the state of Florida lacks jurisdiction to either grant, deny, or even hear a petition for writ of certiorari? That's because corruption has its price. Corruption has its price. That's why the Supreme Court of the state of Florida can't entertain a writ of certiorari, because corruption has its price. As you might be able to read from the slide here, the text has gotten small. I will read it to you. In 1975, Supreme Court Justices Hal Deckel and David McCain resigned while being investigated by a Florida House of Representatives impeachment committee on separate charges, including allegations that both pulled strings to help friends. McCain, accused of lobbying a lower court to overturn the bribery conviction of one of McCain's political supporters, resigned the day before the House almost certainly would have impeached him, according to this quote I'm reading to you from a newspaper reporter named William Levesque. He's also an author of some books. Here he's writing for what was then called the St. Petersburg Times. The article is written October 28th, 2001. You'll find it in the St. Pete Times at page A14 under the title, Path to Impeach Always Thorny. Reporter Levesque continues, the case, which included evidence that Justice McCain may have accepted a $10,000 bribe, ultimately got McCain disbarred by the Florida bar. Corruption has its price. Don't believe the St. Pete Times? Maybe you can believe what some call the failing New York Times. Can you read I'll try to give you the slides you can download yourself. But this is an image from the New York Times. Around the nation, ex-Florida court judge accused in drug case. September 26, 1982, New York Times says David McCain, who was forced to resign from the Florida Supreme Court in 1975, was arrested Saturday on charges of conspiring to import and distribute more than 10,000 pounds of marijuana. Mr. McCain, 51 years old, was arrested at his home in Lakewood Park, section of Fort Pierce. Law enforcement agents said McCain helped arrange marijuana smuggling operations in Louisiana from May through October of last year. Corruption has its price. In reaction to this, the citizens of the state of Florida amended Florida's constitution and specifically removed the jurisdiction of Florida Supreme Court to hear, decide, grant, deny writs of certiorari. Although the Supreme Court of the United States essentially has discretionary jurisdiction called writ of certiorari, that is not true for Florida's Supreme Court. There's my air quotes. And one of the reasons you might, without disrespect, say that Florida's Supreme Court is less supreme when it comes to a comparison with other state high courts, and certainly when it comes to a comparison with the United States Supreme Court. So we've got about a little less than 15 minutes to go in class. Let's look at these writs again. Petition for writ of mandamus seeks to remedy a government's failure to do something it's supposed to do. It seeks to enforce a clear legal right to the performance of a clear legal duty. A writ of prohibition is a mean by which to seek a greater court's order, preventing a lesser tribunal from doing something it's forbidden to do. A petition of writ of quo warranto is an action to challenge the exercise of some right or privilege, the peculiar powers of which are derived from the state. A petition for a constitutional writ, also known as the all writs power, is an original action filed to preserve a court's jurisdiction that has already been invoked, or to protect a court's jurisdiction that will likely be invoked in the future. So with that said, let's play everyone's favorite game show, Name That Writ. Here I provide you with ludicrous, crazy, silly hypotheticals that attempt to show you when you might choose a particular writ. The hypotheticals build on one another, and they get crazier as it goes on. But stick with me now, and let's play Name That Writ. Name That Writ number one. While scheduling the bench trial in your Florida County Court case, and you understand what a bench trial is, right? That's just like a trial, but we don't seat a jury. Rather than divide the task of the findings of fact going for the jury and the conclusions of law going to the judge, in a bench trial, the judge will do both jobs. The jury isn't there. The judge will make the findings of fact as well as the conclusions of law. So while scheduling a bench trial in your Florida County Court civil case, Judge X says, I'll just hold trial for an hour. That's long enough to make your client feel like he got a fair trial before I rule against him. Then Judge X denies your motion to disqualify him. So the question here now is, name that writ. Constitutional writ, certiorari, mandamus, prohibition, quo warranto. The answer is writ of prohibition. Why writ of prohibition? Because a writ of prohibition is a means by which to seek a greater court's order preventing a lesser tribunal from doing something it should be forbidden to do. Should a county court judge be permitted to put on a farce, a pretend, a hoax of a trial when that judge has already decided that regardless of the outcome of that trial, that judge is going to rule against your client? No, judge should not be permitted to do that. This judge announced on the record that that's what this judge was going to do. A writ of prohibition can be filed to seek an order preventing that judge from doing that, because that judge should be forbidden to do it. But here's the harder question. Where do I file the writ? You saw how the Supreme Court of Florida had jurisdiction to grant many of these writs. When you look at Article 5 of Florida's Constitution, you'll see that the district courts of appeal certainly have jurisdiction to grant most, if not all, of these writs. How about this? You remember our circuit courts? They were hearing plenary appeals, final appeals from county courts. Our hypothetical involves County Court Judge X. As the circuit courts sit in their appellate capacity, they too can entertain extraordinary writs. So where do I file this writ of prohibition seeking relief against this county court judge? Do I file it in the circuit court? Do I file it in the District Court of Appeal? Do I file it in the Supreme Court of Florida? All three have jurisdiction under the Florida Constitution. What does that mean? Do I get to pick one? Do I pick my favorite judge? The answer is no. The answer is this. Although all three levels of court have jurisdiction, not all three will exercise that jurisdiction. The court that will exercise the jurisdiction is the lowest ranking court that has territorial jurisdiction over a final order from the court that you're seeking the writ against. Here, the county court, if it were to enter a final order, that would be appealed to the circuit court. Therefore, the only court that will exercise its jurisdiction to grant a writ against the county court is the circuit court. So the answer here is that you file in circuit court, the one with territorial jurisdiction over that county. Prohibition can remedy many things, such as you saw in the hypothetical. Here's some other examples. Prohibition can remedy a failure of a judge to disqualify himself. Prohibition can remedy a state agency acting in excess of its jurisdiction. It can remedy a court acting in excess of its jurisdiction. Or how about this? You as an attorney are about to be cited for contempt. Typically, in most cases, the alleged contempt didn't happen in the presence of the judge. There'll be an order to show cause to come before the court to see whether you'll be cited for contempt. Don't wait. File the writ of prohibition now. Seek to shut down that hearing where you go before the court and the court decides whether or not to cite you with contempt. Writ of prohibition is the way by which you might do that. Where do I file the writ of prohibition against Judge X? Article 5, Section 3 says the Supreme Court may issue writs of prohibition, so it has jurisdiction. Article 5, Section 4 says the DCA can grant a writ of prohibition, so it has jurisdiction. The circuit courts likewise have jurisdiction. But remember the rule that we discussed. Venue for any extraordinary writ generally follows territorial appellate jurisdiction. So the court with territorial authority in the first instance to review that entity's final orders or judgments, that's the court that will exercise its jurisdiction to enter a writ such as a writ of prohibition. Other courts may have jurisdiction, but they will not exercise that jurisdiction. We've got about 3 minutes left in class, so we can probably cover 2 more hypotheticals. I'll build on the facts of that first hypothetical. Name that writ. Number 2, you win your writ of prohibition from the order denying motion to recuse Judge X. So the appellate court granted prohibition. Now you're back in front of Judge X with that winning prohibition in your hand. And upon that remand, Judge X sets the case for trial in front of Judge X. Judge X denies your motion to enforce the appellate mandate and to transfer the case. Name that writ. Well, you're going to go back to the court where you filed the writ of prohibition. You're going to file either a petition for constitutional writ under the court's all writs power, or you're going to file a motion in front of the appellate court to enforce the mandate. So that's what you're going to file. The extraordinary writ option was the constitutional writ. It's an original action filed to preserve a court's jurisdiction that's already been invoked, or to protect a court's jurisdiction that will likely be invoked in the future. So you already invoked it. You already won. But the lower court didn't listen. So go back to where you won and tell them to make the lower court listen. A constitutional writ can be used for other reasons, such as to stay lower court proceedings. Just because you filed an appeal doesn't mean the lower court's going to grind to a halt. You might also need a constitutional writ, all writs power, or you might need a motion for stay. Another option, to enforce an appellate mandate, which we just talked about in our hypothetical. Another option, to enjoin or stop an action that would prevent the higher court from exercising its jurisdiction. Got a couple minutes left. Bear with me now. Be patient. We can get through this. On these facts, where do I file it? And although the Supreme Court and the District Court of Appeal and the Circuit Court all had jurisdiction, only one will exercise it. And that's the lowest tribunal that had jurisdiction. That's the Circuit Court. Remember, although more than one higher court has jurisdiction, the only court that will exercise that jurisdiction is the court with territorial jurisdiction over appeals from final orders of the lower tribunal. So where do I file? I file in the Circuit Court that had territorial jurisdiction over that county. Name that writ. Number 3, last one. You win your constitutional writ from the order denying motion to enforce the appellate court's mandate. On remand, Judge X enters an order transferring the case to Judge R, who was Judge X's sister. Judge R retired years ago. Judge R is no longer a judge. But Judge X enters an order finding that there's just not enough active judges in his county, that the governor was wrong not to reappoint his sister out of retirement. And so by necessity to correct the governor's error, Judge X is appointing Judge R to now be a judge again. Both Judge X and R deny your motions, objecting to Judge R presiding. And the question, the last question before we go, is name that writ. Constitutional writ, certiorari, mandamus, prohibition, quo warranto. The correct answer is quo warranto. Why quo warranto? Petition for quo warranto is an action to challenge the exercise of some right or privilege, the peculiar powers of which are derived from the state. As we talked about, it was a peculiar power of the governor to appoint judges and a peculiar power of the people to elect county court judges. Judge X has usurped those government powers and appointed his sister. So petition for quo warranto, which roughly from the Latin means whose authority, is an appropriate petition. Pro warranto can be used in this case. Here's some other instances. To determine if a state officer or agency improperly exercised its power. Another instance, to challenge a right to hold a public office. Another instance, to challenge a right to hold a government franchise. And of course, where do I file this writ? Well, quo warranto jurisdiction for the Supreme Court is limited. Remember, may issue writs of mandamus and quo warranto to state officers and state agencies. Judge X is a county court judge. It's not a state of Florida statewide judge. Judge X is the judge of that county. The Supreme Court of Florida lacks jurisdiction, does not have jurisdiction to entertain quo warranto petition filed against that judge. District Court of Appeal, the one with territorial jurisdiction over that county, yes, the DCA has quo warranto jurisdiction and the circuit court has jurisdiction. So although you've got two different courts now, the DCA and the circuit court both have constitutional jurisdiction under Florida's Constitution, as always with writs, only one court may properly exercise that jurisdiction. Note, Florida Supreme Court doesn't have jurisdiction, so we can't go to them. But we also can't go to the first DCA because we're going to follow the usual rule for writs and choose the lowest appellate court with territorial jurisdiction. And that's a great rule of thumb when you see these types of hypothetical questions on your final exam. Go to the lowest appellate court that has territorial jurisdiction. Hey, you joined me today, and I really appreciate you doing that. I'm sorry that there aren't live classes. I certainly would prefer to be doing this live. I certainly apologize for the technology difficulties that we suffered this week. I'm going to work very hard over the next 7 days and hopefully overcome those technological problems. But something I'm going to do that's even more important than that, if you don't mind me saying, is that my wife Bernadette and I are going to keep all of you in our prayers. Let's be careful out there. Let's stay happy. Let's stay healthy. Let's keep our chin up. Let's overcome obstacles. And until we meet in this distance learning environment again, may God continue to bless each and every one of us. Thanks for being here tonight. Take care.